The hearing committee has deliberated, and we are in unanimous agreement that there is no discipline short of disbarment that would be appropriate in this case, given the magnitude of the offenses that we have found and the effect upon the profession and the public. I do want to make some remarks as to why we reached that conclusion. This matter has been a fiasco. There's no doubt about it. It has been a fiasco for a number of people, starting with the defendants and moving out from there to the justice system in general. We've heard evidence over the last several days of how that came about. And we are lawyers and a school administrator. We're not psychologists. But you have to ask yourself, why? Why did we get to the place that we got? It seems that at the root of it is self-deception arising out of self-interest. Mark Twain said that when a person cannot deceive himself, the chances are against his being able to deceive other people. And what we have here, it seems, is that we had a prosecutor who was faced with a very unusual situation in which the confluence of his self-interest collided with a very volatile mix of race, sex, and class, a situation that, if it were a plot of a John Grisham novel, would be considered to be perhaps too contrived. And at that time, he was facing a primary. And yes, he was politically naive. But we can draw no other conclusion but that those initial statements that he made were to further his political ambitions. And having once done that, and having seen the facts as he hoped they would be, in his mind, the facts remained that way in the face of developing evidence that that was not in fact the case. And even today, one must say that in the face of a declaration of innocence by the Attorney General of North Carolina, it appears the defendant still believes the facts to be one way, and the world now knows that is not the case. We are required under our rules to consider certain aggravating and mitigating factors under Rule .0114W. And those are set forth in the rule, and I'm going to say what aggravating and mitigating factors we have found. We have found as aggravating factors dishonest or selfish motive, a pattern of misconduct, multiple offenses, refusal to acknowledge wrongful nature of conduct in the respect of the handling of the DNA evidence. We do find that he has made some acknowledgement of his wrongful conduct in regard to the pretrial statements. The vulnerability of the victim, or the victims in this case, and primarily the victims are the three young men who were wrongfully charged. And we find also as an aggravating factor substantial experience in the practice of law. As mitigating factors, we find absence of a prior disciplinary record and reputation for character. We expressly find that the aggravating factors outweigh the mitigating factors. This matter appears to be an aberration in a couple of respects. It appears to be an aberration in the life and career of Michael Knifeland. It appears also to be an aberration in the way justice is handled in North Carolina. It's an illustration of the fact that character, good character, is not a constant. Character is dependent upon the situation. And probably any one of us could be faced with a situation at some point that would test our good character and we would prove wanting. And that has happened to Mike Nightfall. But the fact that it has happened and the fact that we have found dishonesty and deceitful conduct requires us, in the interest of the protection of the public, to enter the most severe sanction that we can enter, which is disbarment. I want to say something about who the victims are here. The victims are the three young men to start with, their families, the entire lacrosse team and their coach, Duke University, the justice system in North Carolina and elsewhere, and indeed prosecutors, honest, ethical, hard-working prosecutors throughout the nation, as we've heard through anecdotal evidence, are victims of this conduct. And in particular, the justice system is a victim of the way this was taken out of, as Mr. Smith testified, taken out of the courtroom and put in the hands of the public. And not only the public in general, but into a media frenzy unprecedented in anyone's experience. As I think anyone who has sat through this entire proceeding, and we've been here now on the fifth day, knows that you can't do justice in the media, you can't do justice on sound bites. The way to arrive at a determination of the facts is to hear in a fair and open proceeding all of the evidence, and then for the trier of fact to determine what the facts are. And we've done that this week. That did not happen and was not going to happen, apparently. This is to say, this is another opportunity to acknowledge, based upon the actual testimony that we have heard over the last several days, and to remind everyone, other than the testimony of Brian Meehan on December 15, 2006, no one had given testimony in a public hearing under oath in this matter until this week. This has given an opportunity to air some, though not all, of the evidence that may relate to this matter. After all, our purpose is limited to the disciplinary matter before us and the specific allegations, and only involves the law license of Mike Nightfall. But we've had an opportunity over the last several days to hear additional evidence. And while it is really not within the purview of the panel to make such a pronouncement, I want to say again that we acknowledge the actual innocence of the defendants, and there is nothing here that has done anything but support that assertion. Finally, I want it to be noted, and it may seem to be a subtle distinction, but it's an important one. It relates to this underlying case, which is, when this is reported, it should be noted not that the state bar disciplined Michael Nightfall, but that the Disciplinary Hearing Commission of the North Carolina State Bar, particularly this panel of the Disciplinary Hearing Commission, disciplined Michael Nifong. That is important because it should illustrate to everyone that there has been a process here. The State Bar, in secret, did not decide to take away the license of Michael Nifong to practice law. The State Bar decided that they had evidence sufficient to go forward and seek to prove to an independent tribunal of triers of fact that his license should be taken away. And it took a long process culminating to this point in order to do that. And that's due process. And that's what was nearly hijacked in the case of the Duke lacrosse defendants. That is about the only thing, those are the only things that come to mind that are good about this entire situation. It's been truly a fiasco is not too strong a word. But it could have resulted from a lapse of character of practically anyone, not just in particular Mike Nifong. We've heard anecdotal evidence of the harm that it has caused. The actual harm is very difficult for one to get one's arms around. But I certainly hope that this process will help assuage the harm and stop the ripples that seem to start when the stone was thrown in the pond. They just got bigger and bigger. But hopefully they will ebb from this point forward. We expect to enter a written order in the near future. I won't put a timetable on it. It will take a little time. But again, that will be a final order, and I understand the defendant has waived his right to appeal it. So unless there's anything further for us to address,